Chris Akiri joins us. He's a legal practitioner to look at the Kogi election matter. Good morning and thanks for joining us. Quite a lot happening in the polity, and you've been away looking at so many of these things happening in the country. Now we're getting to look at Kogi State. For the time you've been away, what were those political matters that you wished you would have actually bring your voice on?
I wish I had been. Was here when they were discussing Taraba issue, Taraba elections, and the pronouncement of the tribunal on the gubernatorial issue. You know, making Elijah Aisha something the governor, and turning away the other person. That's what I would have loved to be here to discuss.
In law, as a legal practitioner,
Yes.
what's your interpretation of that particular judgment?
It was delivered per incuriam. What I mean by per incuriam is when a judgment is wrongly delivered, then we say the judgment was delivered per incuriam because it was without regard to the law. You know, the law is so clear. I was writhing in pains in the US when the election tribunal gave it judgment. I mean, it's contrary to the law. And I was just praying that the case is not sub judice by the time I come back, so that I could still talk about it. Yes.
Okay, now let's come back to what is burning now, which is Kogi State, and every moment a different angle pops up on this particular matter. And looking at headlines, what you see now is even within the APC camp, we're getting to see a bit of, we're not using the word confusion now, we're talking about a bit of a split, for some asking
Yes.
the late Audu's son to take over, while some others are looking at the political party. But again, let's look at that inconclusive nature of that particular election and what went down.
Yes.
As a lawyer, how would you have loved to see this go?
You see, now as a lawyer, I won't shout. There's a hiatus.
Because it's a bit political and a bit legal.
Yes, it's in fact, it's very legal. Because I've listened to so many analysts, talking about this issue, going up and down, but a particular thing escapes them, and I will talk about it. They talk about Section 181 of the Constitution, but Section 181 is on when a person has been elected and he has been declared winner, and just before he swears the oath of allegiance and the oath of office, he dies. That's that's what Section 181 is all about. So we don't talk about that at all because the election was declared inconclusive. So Section 181 of the Constitution doesn't come in at all. When you look at Section 36 of the Electoral Act, it says before the commencement of any poll, any election, if somebody dies, that is for that. But what we are saying now is the polls had commenced. They had not only commenced, they were almost finished, except that the electoral umpire said they are inconclusive. So the only answer to that question, to resolve that question, I mean, it is not correct to say there is a lacuna or there is a constitutional crisis, or there is nothing like that at all, because the Constitution is, I mean, the law on election is so clear. The Electoral Act 2010, as amended, in 2011, is so clear on this. So there is no lacuna at all, and now there is no crisis. You take a look at Section 33, and that's the thing. I have brought
of the Electoral Act.
Of the Electoral Act, Section 33, which so many people have also talked about. But what has eluded them is a simple what's the name of this? A word, a simple word, which is except. They didn't look at the word except. You know, it says, no political party shall be allowed to change or substitute its candidate whose name has been submitted pursuant to Section 32 of this Act, except, you know, the accent should be put on the word except. Oh, I should have given you, I brought another one, I brought one for you too.
I have the copy here.
You have a copy?
Yes, thank you very much.
You see, if you open Section 33.
Go ahead.
Yes, open Section 33, you see, no political party shall be allowed to change or substitute its candidate whose name has been submitted, pursuant to Section 32.
31.
And 31 is there?
Yes.
No, okay. 31 of this Act, except, that is the word, which has eluded so many analysts, except in the case of death or withdrawal by the candidate. That's the provision. Now, that one can be reframed like this. A political party, any political party shall have the right to substitute or change any of his candidates if that occurs. That is the way, that's another way of rephrasing it. A political party shall have the right to, only if death occurs, he shall have the right to substitute or change its candidate, any of his candidates, if death occurs. Any of his candidates whose documents have been submitted in accordance with Section 31 of this document, of this law.
So so you say the error here is looking at it when you say a political party shall not be allowed, not be allowed. But you have to go back to look at the exception. Yes. The exception now.
Correct. In other words,
overrides.
In other words, the political party, the APC this time around, the APC has the right to substitute any any person for the substitute somebody for the dead person. Abubakar Audu, who passed away, now he has passed on. He was a candidate of the APC, and now he has died. So you read that Section 33 properly, and I told you that the word "except" is what has eluded so many analysts.
So sorry, Nyota. So for 33, because it's quite interesting that you've just brought this up.
Yes.
For 33, saying that a political party shall not substitute or withdraw its candidate, except on two of these, on two of these grounds,
Correct.
case of death or withdrawal of the candidate. So
And
the candidate can as well just maybe during the election say, I'm no longer interested in this and I'm opting out.
And then he withdraws.
He withdraws.
If he withdraws,
so the party can
now change. Can now change him or can substitute somebody else for him.
What about those who also argue and by saying that this is before, it can only occur before the process? We're talking about the election as a process.
You see, this is the way the law is. You see what the Constitution has said. Other statutes may not repeat. Now, the Constitution in Section 181, talks about a situation in which an election has been concluded and somebody has won, has been declared winner. But just before he swears to the oath of allegiance and the oath of office, he dies. So that's already settled. Then this statute, this Electoral Act takes over from there and says, Section 36 says, before the election, before the election commences, if somebody dies, what should be done is stated there. Then Section 33 says, at any time, if anybody should die or should withdraw, the party has, because otherwise the party has no right to withdraw or to substitute anybody apart from that.
Mr. Akiri,
yes.
If I may come in here. Staying with the 33 and the 36.
Yes.
33 here.
Yes.
Did not say anything, did not give a time frame.
No, it says before the commencement.
No, 33 didn't give any time.
You mean 33?
33
well,
and the
I thought you were talking about 36.
A political party shall not be allowed to change or substitute its candidate whose name has been submitted pursuant to Section 32 of this Act, except in the case of death or withdrawal by the candidate.
Okay.
That's 33. 36.
Yes.
If after the time for the delivery of nomination paper and before the commencement of the poll, a nominated candidate dies, the Chief National Electoral Officer or the resident electoral commissioner shall, being satisfied of the fact of the death, countermand the poll in which the deceased candidate was to participate.
And set another date for the polls within 14 days.
But what we're saying here,
yes.
That 33 was what the Attorney General quoted. But tie that up with the other portions of the Constitution and the Electoral Act that talks about prior to the commencement of the election. How would this work out? This one, the election has already started.
Yes.
And indeed, if INEC did not say the election was inconclusive,
yes,
they would have announced a candidate.
Yes.
Then another portion of the Constitution would have stepped in. I mean, the deputy would have now stepped up
yes.
to be sworn in.
Yes.
But in this case now, the election is still ongoing.
It's still ongoing.
So,
and has been declared inconclusive by the electoral umpire. So it's still ongoing.
So you're saying that the APC is right to be going
Very
to nominate?
right. Yes.
But they're talking about running another primary.
No, there's no primary. The rerun elections must take place. The APC must elect a new candidate as governor. Faleke came up on the television yesterday to say, oh, okay, I want to be declared a governor. That he made a mistake. He doesn't know the law. He doesn't know that the elections had not been concluded. He wanted to be made governor-elect when the elections had not been concluded. There are sections in the Constitution governing that, and there is a section in the Electoral Act governing that. All right, so before the election takes place, the Electoral Act is talking about it. But this one is telling you can see no time is stated in Section 33 that either before or after. It's a combined thing. At any time after the submission of the documents to INEC,